Welcome to the Tejswi IP Show. In this podcast, we dive into the world of intellectual property, like patents, copyright, trademark, geographical indication, design. Also analyze the recent event in IP world. Today, we're taking a look at a stack of documents focused specifically on patent laws in India. It seems someone out there is looking to really get a solid handle on the fundamentals and, well, our job today is to help you unpack this material.
That's right. We've got a source here that really covers the basics. It talks about what patents are, how they work here in India, a bit of the history, the requirements you need to meet, rights, obligations.
The whole 9 yards, basically.
Pretty much how to get one, what happens if someone infringes.
Yeah.
It's a really foundational look at Indian patent law based purely on what's in this document.
So think of this as our guided exploration through these core ideas. We'll navigate through it, pull out the most crucial information, and try to present it in a way that's easy to grasp.
The aim is for you, listening in, to walk away with a solid understanding of the essentials of patent law in India, based entirely on what this material tells us.
We'll take it step by step, building up that picture.
Sounds like a plan.
Okay, let's start right at the beginning, just like the source does. What is a patent? The source fundamentally describes it as an exclusive right granted by the government to an inventor. But what does that exclusive right actually mean in practice, according to our source?
Well, that exclusivity is really the heart of it. According to the source, it means the person who holds the patent gets the legal power, the authority, to stop others from doing certain things with their invention.
For a limited time, right?
Exactly, for a limited time. Specifically, they can prevent anyone else from using the invention, making it, selling it, or even just offering it for sale within India, assuming it's an Indian patent.
And it's not just for brand new, earth-shattering things.
No, the source notes this applies to improvements too. Significant improvements on previous inventions can also get this exclusive right. It's basically about giving the inventor control over their innovative work.
Control, but with a reason behind it. The source talks about the main motto.
Absolutely. The fundamental idea, as this material describes it, is to encourage inventors. By giving out these exclusive rights, the government provides a really strong incentive.
Makes sense.
It motivates people to put in the time, the effort, the money, into developing new technologies, and importantly, disclosing them to the public. Because they have this temporary window where they can potentially make back their investment and profit exclusively, it's a system designed to push progress forward by rewarding that contribution.
So it's like a bargain.
Yeah.
You tell us how your invention works, and society gives you a temporary monopoly. The source also phrases this in more modern terms.
It does. In today's language, the source characterizes a patent as a right you get for something that meets 3 key criteria. It has to be new, it must be useful, and critically, it needs to be non-obvious.
New, useful, non-obvious.
Right. And these criteria apply to specific types of inventions. The source makes it clear a patent can be for a process, a machine, an article of manufacture, or even a composition of matter. So that defines the kind of things that can even be considered for patenting.
That distinction process, machine, article, composition, seems important. And the word patent itself, the source mentions its origin, is kind of interesting.
It is, yeah. The source traces patent back to the Latin word patere. Pater, yeah, which means to lay open or to make available for public inspection. And that historical root is quite telling, actually. It highlights a really fundamental part of the patent system.
The disclosure part.
Exactly. In exchange for that exclusive right, the inventor must fully disclose their invention to the public. That disclosure becomes part of the public record, adds to the overall technical knowledge base, even while the inventor temporarily controls its commercial use.
That laying open idea really brings home the public benefit side of that bargain. Now, you mentioned the core requirements, new, useful, non-obvious. The source sets these out as 3 basic tests for patentability. Let's break those down. Starting with novelty.
Okay, sure. The first fundamental test the source describes is novelty. This just means the invention has to be genuinely new. The source clarifies what not in existence means here. The invention must not have been known to the public in any way.
Like written down, talked about.
Exactly. Orally, in writing, through public use, or any other way before the date the patent application is filed. If your invention or something very close to it is already out there in the public domain when you file, well, it fails the novelty test. Simple as that.
So even if you invented it yourself, if someone else already made it public before your filing date, you're out of luck for a patent. That filing date is critical. What about the second test?
The second one is Non-obviousness. The source uses the term inventive step for this, which is pretty common terminology. It means the invention can't just be a minor tweak or a predictable change to something already known.
It has to be a real leap.
It needs to represent a significant technological advancement or have real economic importance, or maybe both. And crucially, the source says this step must not be obvious to a person skilled in the art.
Ah, the famous person skilled in the art.
Right, it's a hypothetical standard. Not a genius inventor, but someone with average knowledge and skill in that specific technical field. If this average person, looking at everything known before your filing date, could have easily come up with your invention, then it's considered obvious, and it fails the non-obviousness test.
That skilled person benchmark is interesting. It sets a bar for what counts as truly inventive. And the third test.
The third basic test is usefulness, or what's often called industrial application. The source says the invention must be useful in a genuine, bona fide way. It needs to have some practical utility.
Can't just be for illegal stuff, presumably.
Right. The source mentions that. It can't be solely for illegal work, and it needs to be beneficial or capable of being used in a real-world way. The source actually references Section 2AC of the Indian Patents Act here, defining capable of industrial application as meaning the invention can be made or used in an industry. It can't just be a cool idea on paper. It needs a practical function that could be applied industrially.
So, the big three. New, inventive step, non-obvious, and industrially applicable, useful. Got it. The source also mentions how long this protection lasts.
Yes, it confirms that a patent granted in India has a limited term. It's 20 years.
20 years from grant.
No, and this is important. It's 20 years from the date the application was filed, not the date it was granted. That fixed term gives certainty about when the invention eventually enters the public domain for anyone to use freely.
And this 20-year protection is only in India, right? The source seemed clear about the territorial nature.
Absolutely critical point. The source explicitly states a patent is a territorial right. It's only legally effective and enforceable within the borders of the country that granted it.
So an Indian patent protects you in India, but not, say, in the US or Europe.
Exactly. You can't use your Indian patent to stop someone making or selling your invention in Germany. If infringement happens in Germany, you need a German patent and you need to sue in Germany. Legal action is tied to the territory where the patent is granted and where the infringement occurs.
So for international protection, you generally need patents in each country. Though the source does mention something called the PCT Patent Cooperation Treaty as a way to maybe streamline the initial filing.
Yes, the PCT system. As the source describes it, it's a way to file one single international application that can act as a placeholder in many member countries.
A placeholder.
Yeah, it effectively delays the deadline for filing separate national applications in those countries for a certain period. This gives inventors more time to decide where they actually want to pursue patent protection and get their funding together.
But it doesn't give you a world patent.
No, absolutely not. The source is clear on this. The PCT centralizes some initial steps like the search and preliminary examination, but the final decision to grant a patent always rests with the individual national or regional patent offices. Once the application enters the national phase in each country, it's examined according to that country's laws.
Okay, so PCT helps manage the early stages internationally, but the grant is still country by country. The source also repeats some India-specific requirements.
Right, just reinforcing the basics. Under Indian law, the source confirms an invention must be new and useful and fall into those categories: machine, article, substance made by manufacturer, or a manufacturing process. It also mentions that historical point again about medicines, drugs, and chemicals.
The process versus product thing.
Exactly.
Yeah.
Before the 2005 amendment for those categories, you could often only patent the process of making them, not the new substance itself. And the source also clarifies who can apply. It must be the true and first inventor, or someone who legally got the rights from them, like an employer through an assignment agreement, or someone who bought the invention rights.
Okay, so that covers what a patent is and the basic requirements. But as you said, the source is very clear that not everything can be patented, even if it seems new and useful. There are specific exclusions in Indian law. What does the material say is definitely not patentable?
Yeah, this is covered in Sections 3 and 4 of the Indian Patents Act 1970, according to our source. These sections list things that the law explicitly says are not considered inventions for the purpose of getting a patent.
And the list in the source seems pretty broad. It starts with really fundamental things like scientific discoveries or mathematical methods.
Yes, those are listed. The thinking often is that these are, fundamental principles of nature or abstract ideas, not concrete technical solutions you can apply. The course also explicitly excludes aesthetic creations, things like art, literature, music.
Right. Those usually fall under copyright or design rights.
Exactly. Also on the list, schemes, rules, or methods for just performing mental acts, playing games, or doing business, and mere presentations of information. And significantly, computer software per se.
That per se qualifier on software is always a tricky area, but the source clearly lists it as an exclusion here. That's quite a lot of intellectual effort that doesn't fit into the patent framework.
It is. The source also brings up other categories that are typically not patentable, sometimes referencing principles similar to European law. These include methods for medical treatment, surgery, therapy, diagnosis performed on the human or animal body. Also, new varieties of plants or animals.
Are those protected elsewhere?
Often, yes. There are usually separate systems like plant breeders' rights. The source kind of hints that for these complex areas, you'd really want to talk to a patent attorney. And critically, the source mentions inventions, where the intended use would be contrary to public order or morality.
Like the examples given.
Yeah, it gives pretty stark examples like landmines or letter bombs. Basically, if an invention is designed for something inherently harmful or against public morals, it's not patentable. Doesn't matter how novel or clever it is.
That public order exclusion really underscores that the patent system operates within societal values. So even if you tick the boxes for novelty, inventive step, and utility, you still have to make sure your invention isn't on this exclusion list in sections 3 and 4.
Exactly. Sections 3 and 4 act as a sort of gatekeeper, defining the boundaries of what the Indian patent system is actually designed to protect, according to the source material.
Now, the source gives us a quick but useful look back at the history of patent law in India. It wasn't always like it is now. Let's trace that evolution a bit based on what the material tells us.
Right, it shows a kind of consistent goal, but the law has changed over time. The source points to the very first formal step being Act 6 of 1856. The stated aims back then were clear. Encourage useful inventions of new manufacturers, and importantly, get inventors to actually reveal them to the public. So that core idea incentive for disclosure was there right from the start.
But that 1856 Act didn't stick around for long.
No, the source says it was repealed pretty quickly by Act 9X of 1857. The reason given is specific. It didn't get the official okay from the British Crown.
Ah, procedural hurdles even back then. So they had another go. What came next?
They introduced fresh legislation, Act XV of 1859. This one, according to the source, granted exclusive privileges.
Not patents.
Exclusive privileges, yeah, specifically for useful inventions. Similar concept, different wording. This act also apparently extended the priority period for filing abroad from 6 months to 12. And an interesting detail the source mentions, it specifically said importers couldn't be considered the inventor. The privilege was meant for the actual creator in India.
Interesting. Already wrestling with who counts as the inventor. The source says this 1859 Act then got amended a few times.
Yes, showing they were tweaking it. Amendments happened in 1872, 1883, and 1888. It suggests the system was being actively shaped during that late 19th century period.
And eventually these earlier laws were sort of rolled into one.
Pretty much. Those previous acts were repealed and replaced by the Indian Patent and Design Act, 1911. This was a major law covering both patents and industrial designs for quite a long time, setting the framework until the modern era.
And the big change leading to the current foundation was the Patents Act 1970.
Correct. The Patents Act 1970 came into force April 20th, 1972. The source describes it as replacing the 1911 Act and forming the basis of today's patent law in India. It notes it was largely based on recommendations from the Justice Ann Rajagopala Iyengar committee report.
So a major review led to it, and it had that specific rule about drugs and chemicals.
Yes, that was a key feature highlighted by the source. The 1970 Act allowed patents for the process used to make things like drugs, food, and chemicals, but explicitly not for the chemical substance itself, even if it was new. This really shapes certain industries, especially pharmaceuticals, encouraging different ways to make the same end product.
That process-only approach for key sectors was a defining characteristic. But the source also points to a big amendment more recently that's shifted things again?
Absolutely. The Patents Amendment Act, 2005, was a major overhaul. This amendment extended product patents to basically all fields of technology that included food, medicine, chemicals, microorganisms, the areas previously limited to process patents.
Bringing India more in line with international norms.
It seems that way, yes. That change meant the old provisions for exclusive marketing rights, or EMRs, which were sort of temporary rights for pharma and agrochemical products during the transition, were repealed. They weren't needed anymore once full product patents were available.
So EMRs were like a bridging mechanism. Did the 2005 amendment bring in other significant features?
Yes. The source notes it also formally introduced or strengthened key parts of the system. This includes provisions for compulsory licenses, which we'll get to, as a limitation on rights and robust procedures for both pre-grant and post-grant opposition.
Meaning people could challenge patents?
Yes, challenge an application before it's granted, or challenge a patent after it's granted, allowing third parties to raise objections formally.
So this historical look shows a clear path from early exclusive privileges to a system that evolved, adopted process patents for some areas, then shifted to broader product patents, while also adding checks and balances like opposition and compulsory licensing. It's definitely not been static.
It really demonstrates a legal framework adapting over time, responding to internal reviews and probably external factors too, trying to balance innovation incentives with public needs and international standards, as reflected in these specific laws, and changes the source highlights.
Okay, let's shift from the history to the nuts and bolts. If you're an inventor in India today, how do you actually go about getting a patent? The source lays out a procedure, step by step.
It does. It gives a pretty clear roadmap. The very first step is really foundational. Document your invention thoroughly. The source really stresses writing down everything about your idea or concept in detail.
Like what specifically?
Defining the technical field, giving a detailed description of what it is, explaining exactly how it works, and spelling out the benefits or advantages it offers. The source also recommends keeping good R&D records, lab notebooks, dated and signed as proof of when you invented it.
So, step 1. Get it all down on paper. What about pictures?
Step 2 is visual documentation. The source says including diagrams, drawings, sketches. These are important. They help explain the invention, especially its structure or how parts work together, making it easier for the patent office and later the public to understand.
Describe it, draw it. Then what's the next vital check before you even think about filing?
Step 3 is a crucial legal check, according to the source. Is your invention even patentable subject matter? We talked about those exclusions in sections 3 and 4. You need to check if your invention falls into one of those non-patentable categories.
Like a mathematical formula or a business method?
Exactly. If it's clearly excluded by the law, then, well, you can't get a patent for it in India, and that's the end of the patent road for that idea.
Okay, assuming it passes that first filter, what does the source suggest next?
Step 4 is what the source calls patent discovery. It sounds a bit grand, but contextually it seems to mean doing a thorough search.
A prior art search.
Essentially, yes. Searching existing patents, scientific papers, public disclosures worldwide to see if your invention really meets those core patentability tests. Is it novel? Does it have an inventive step? Is it non-obvious? And does it have industrial application? Is it useful? This search helps you gauge your chances and might affect how you write your application.
Right, so document, check eligibility, search for prior art, then you're ready to file.
Step 5 is the actual filing with the Indian Patent Office. The source mentions 2 main ways to do this, depending on where you are in your R&D. If you're still working on it, maybe you haven't got all the results.
You can file a provisional.
Exactly. You can file a provisional application. The source lists the benefits. You secure an early filing date, which it calls very important in the patent world, and that date is key for judging novelty. It also gives you 12 months to finalize your invention and file the full, complete specification. Plus, it's usually cheaper up front.
But there's a catch.
The catch is you must file the complete specification within those 12 months. If you don't, the source says the provisional application lapses, it's considered abandoned, and you lose that crucial early filing date.
So it buys you time, but you have to follow through. What if your invention is already fully developed?
Then you can skip the provisional step if you want. If you have all the details, results, everything ready, you can file the complete specification right away with your initial patent application. The provisional is optional in that case.
Okay, so you've filed the complete specification either upfront or within 12 months of a provisional. What happens next publicly?
Step 6 is publication. According to the source, the application gets published in the official patent journal, typically 18 months after your earliest filing date, provisional or complete. This makes the details public.
Can you get it published faster if you want?
Yes, the source says early publication is possible. You can request it, pay a fee, and then it's usually published much sooner, maybe within a month of the request. Could be useful for signaling to the market or potential investors.
Once it's published, does the patent office start looking at it right away?
Not automatically. Publication is just making it public. The actual examination only kicks off when you ask for it. Step 7 is filing a request for examination, or RFE. The source is emphatic. The application is only scrutinized after the RFE is filed.
And there's a deadline for that RFE.
Yes, there's a time limit from the initial filing date, though the source doesn't specify exactly how long. Once the RFE is in, the controller of patents assigns your application to a patent examiner.
And what's the examiner looking for?
They do a deep dive. The source lists the checks. Is it patentable subject matter? Is it novel compared to prior art? Is the description clear? Lack of clarity is checked. Does it involve inventive steps? Non-obviousness. Does it have industrial application? And the source also mentions by enabling.
Enabling.
Yes, that's patent speak for. Is the description detailed enough that someone skilled in that technical field could actually make or use the invention without having to do excessive experimentation? The disclosure needs to be sufficient.
Makes sense. The laying open requires actually explaining how it works. What comes out of the examiner's review?
The examiner issues the first examination report, or FAR. This whole back and forth is called patent prosecution, according to the source. The FAR lists any objections the examiner has. Maybe they found prior art that questions novelty, or the claims aren't clear, or they think it's obvious. This report, including the cited prior art, is sent to you, the applicant.
And getting objections is pretty normal.
The source says most applicants get objections. Step 8 is your chance to answer the objections. This is critical. The source advises analyzing the report carefully, probably with a patent agent's help. You need to argue why your invention is patentable over the prior art, maybe clarify things, or possibly amend your claims to overcome the issues. You're essentially making your case to the examiner.
It's a dialogue, potentially with amendments.
Oh.
What happens if your response satisfies the examiner?
Step 9 is clearance of objections. This might involve more back and forth between you and the controller's office. You argue your points, provide evidence if needed, maybe make agreed upon amendments. The source stresses this is your chance to prove novelty and inventive step. If, finally, the controller decides the application meets all requirements and is in order for grant, as the source puts it,
then you're almost there.
Almost there. The application is accepted and moves to the final step. Step 10, grant. Once everything's cleared, the patent is officially granted. This grant is then announced publicly in the official patent journal, which is published periodically.
Wow. That's quite a journey. Documentation, searching, filing, publication, examination request, arguing with the examiner, clearing objections, and finally grant. It really highlights how rigorous the process is based on this source.
It absolutely does. It requires careful preparation, understanding the legal hurdles, and actively engaging with the patent office throughout the prosecution phase.
So let's say an inventor makes it through all that and the patent is granted. What rights do they now officially hold, and what are their responsibilities or the limitations on those rights, according to the source?
Right. Once granted, the patentee has specific legal powers. The big one, as we touched on, is the right to exploit it exclusively. This means only the patent owner or someone they authorize can legally make, use, sell, or distribute the patented product in India or use the patented process. That's the core commercial advantage, lasting for the patent term.
And they don't have to exploit it themselves.
No, which leads to the second right, the right to grant license or assign the patent. They can choose to transfer the patent entirely, assign it, or just give permission to others, license it, to use the invention, usually for some kind of payment or royalty.
Is there paperwork involved for that?
Crucially, yes. The source states any license or assignment must be in writing and must be registered with the controller of patents. This registration is needed for it to be legally valid and for the assignee or licensee to prove their rights later if needed. It adds formality and public record.
What if the patent owner decides they don't want the patent anymore?
They have the right to surrender it. But the source notes it's not instant. Before the surrender is accepted, notice goes out to anyone with a registered interest, like a licensee, so they can object. It's also published in the official gazette for others to oppose. This stops someone harming others' interests by just dropping the patent suddenly.
And the most obvious right, if someone steps on their toes,
The fundamental right to sue for infringement. If someone uses the patented invention without permission, the patentee can take them to court. The source specifies they can file a lawsuit in a district court with the right jurisdiction to stop the infringement and seek damages.
Okay, so those are the powers. Exploit, licensee sign, surrender, sue. But these rights aren't unlimited. What obligations or limitations does the source mention?
Several important ones, often related to public interest. First, government use. The central government can use or even acquire a patented invention, but only for its own purposes. Under certain circumstances, the government can also restrict or prohibit the patentee's use.
And there was that special rule for medicines.
Yes, a very significant one. For patented medicines or drugs, the source states the government can import them for its own use or for distribution in government healthcare facilities without the patentee's consent and without paying royalties. That's a powerful tool for public health access. More generally, the government can also sell items made using a patented process, maybe paying royalties, or acquire the patent itself by paying compensation.
That definitely shows public need trumping exclusivity in critical areas. What about compulsory licenses?
Compulsory licenses are another major check. The source explains if a patented invention isn't being worked properly in India, maybe it's not being made available enough to meet public demand, or the price is unreasonably high, the controller can grant a compulsory license to someone else.
Allowing a third party to make it.
Yes, without the patentee's permission, though usually with royalty payments set by the controller. The source explicitly frames this as a government power, for example, to let a generic company make cheap medicine in the public interest, even if a patent is valid. It can also happen if you need to use one patent to be able to work another related patent.
So the message is, don't just get a patent and sit on it if the public needs the invention. If you don't work it adequately, someone else might get permission. Is revocation possible too?
Yes, revocation is mentioned as a possibility if the patent isn't being worked sufficiently to meet public demand. It's the ultimate sanction, reinforcing the expectation that the patent should lead to public benefit during its term.
What about inventions related to national security?
Special rules apply for inventions for defense purposes. The controller can order secrecy, restricting publication or communication. If that happens, and the inventor can't exploit it, the central government might use the invention itself, usually paying royalties to the applicant.
And lastly, what if a patent lapses but then gets restored?
For restored patents, there's a limitation. If a patent lapses, say, for missed fees, but is later brought back into force, the patentee cannot sue for infringement that happened during the time the patent was lapsed specifically, between the lapse date and the date the restoration application was advertised. This protects people who might have started using it when they thought it was off-patent.
It's really clear from the source that while Indian patents offer strong exclusive rights, the system builds in significant checks, balances, and obligations. Government use, compulsory licenses, revocation possibilities, defense needs, protection during lapses, all seemingly aimed at ensuring the public interest is ultimately served.
Absolutely. The source portrays a system that grants exclusivity but demands responsible use and provides mechanisms for intervention when necessary.
Okay, let's turn to enforcement. The source mentioned the right to sue. What actually counts as patent infringement, according to this material?
Infringement, quite simply, is defined by the source as the unauthorized use, production, sale, or offer for sale of a patented invention. It's when someone else does something that falls under the exclusive rights granted by the patent without getting permission from the patent owner. This applies broadly. Utility patents, design patents, even plant patents are mentioned generally by the source.
The source also talks about direct versus indirect infringement. What's the difference?
Right. Direct infringement is the most common and straightforward type, according to the source. This happens when the product or process being accused literally falls within the scope of the patent's claims. It might be an exact copy, or it might perform substantially the same function in the way described in the patent. It's a direct overlap.
And indirect sounds less direct.
Naturally. The source breaks indirect infringement into two kinds. First, there's infringement by inducement. This is when a third party actively causes or encourages someone else to directly infringe the patent.
How would they do that?
The source gives examples. Selling parts that are only useful for making the patented invention. Selling a product with instructions that tell the user how to use it in a way that infringes a patented method, or licensing out technology that's actually covered by someone else's patent. The key here, the source notes, is that the inducer must assist intentional infringement by the direct infringer, but they don't necessarily need the specific intent to infringe the patent themselves.
So they help someone else infringe knowingly. What's the other type of indirect?
The second is contributory infringement. The source describes this as selling components or materials specifically made or adapted for use in a patented invention, which have no other substantial non-infringing commercial use. There's overlap with inducement, the source admits. For contributory infringement, the source uses the phrase high level of delay required from the seller, which seems odd. It likely means a high level of involvement or knowledge or specific intent regarding the infringing use. It clarifies the seller must have direct infringement intent for it to be contributory.
That intent distinction is subtle.
It is. And critically, for both inducement and contributory infringement, the source stresses that an act of direct infringement by someone else must have actually happened. You can't be liable for contributing to or inducing infringement if no direct infringement ever took place.
That makes sense. You need an underlying infringement first. The source also mentions the doctrine of equivalence and colorable variation here. How do they fit into infringement analysis?
They're about determining the scope of infringement. It's not always about a perfect, literal match. Infringement can be literal, where every single element in a patent claim is found exactly in the accused product or process. Or it can be under the doctrine of equivalence. The source explains this doctrine allows a court to find infringement, even if there isn't a literal match, if the accused product or process performs substantially the same function in substantially the same way to get substantially the same result as the claimed invention.
So it stops people making tiny, insignificant changes just to avoid literal infringement.
Exactly. It's meant to protect the patentee against minor variations that still capture the essence of the invention. The source calls it an equitable rule to cover the inventor's true contribution beyond just the literal words.
Does this mean the patent covers almost anything similar? Are there limits?
Oh yes, the source is clear it's not unlimited. The doctrine of equivalence is restricted. Two key limitations mentioned are prosecution history estoppel, meaning you can't use equivalence to recapture something you explicitly gave up during the patent application process to get the patent granted. And second, the principle of the prior art, the doctrine, can't extend coverage to encompass anything that was already known or obvious before your invention.
So the doctrine expands reach, but not infinitely. It's constrained by the patent's history and what was already public knowledge. The source outlines how courts might approach this analysis.
Yes, it lays out a kind of logic flow based on the source. First, figure out the proper legal meaning and scope of the literal claim language. What do the words actually cover? Second, compare those literal claims to the accused device process. Is there a direct literal violation? Third, if there's no literal violation, then analyze if the scope still covers the accused device under the principle of equality, the source's term here for doctrine of equivalence, remembering, of course, those limitations we just discussed.
Okay, so literal check first, then equivalence check, but only within the bounds set by the prosecution history and prior art.
That seems to be the structured approach the source describes for determining if infringement has occurred.
Now, if the court goes through all that and decides, yes, infringement has happened, what remedies can the patent owner ask for? What can the court do, according to this source?
The source indicates that losing a patent lawsuit can be costly for the infringer. It lists the main types of remedies available to the patent owner: monetary relief, equitable relief, and potentially recovering costs and attorney fees.
Let's break down monetary relief. What kind of money are we talking about?
Usually damages to compensate for the harm. The source mentions indemnity compensation, where the patent owner can recover profits they lost due to the infringement if they can prove the patent's value and the loss. It also highlights increased damage.
The triple damages thing.
Yes, in cases of what the source calls will or violation of will, which we interpret as willful infringement, where the infringer knew about the patent and infringed anyway, damages can be increased up to 3 times the actual compensatory amount, a serious penalty for deliberate infringement.
Is there a time limit on claiming these damages?
Yes. The source specifies 2 key limits. Damages can only be claimed starting from the date the patent was actually issued, granted. And you can only claim for infringement that occurred within the 6 years before you filed the lawsuit. You can't wait indefinitely.
Right, you need to act reasonably promptly. What about equitable relief? Getting the court to make them stop.
That's equitable relief, usually in the form of injunctions, as the source mentions. Court orders telling someone to stop doing something. 2 types are described. A preliminary injunction. This can be requested early in the lawsuit to stop the alleged infringing activity, like making the product, while the case is still being decided. It prevents ongoing harm before the final verdict. and a permanent injunction. This is a final court order issued after infringement has been proven. It permanently stops the infringer from continuing the infringing activities.
So the remedies combine money for past harm, potentially multiplied for willfulness, and court orders to stop the infringement going forward, both during the case and permanently after a win.
That's the package of remedies the source outlines, designed to compensate the patent owner and enforce their exclusive rights.
Well, we've certainly worked through a lot of ground based on this source material, defining patents in India, tracing the history, detailing the complex procedure to get one, outlining the rights and also the significant obligations, and finally looking at what happens when those rights are infringed and what remedies exist.
Indeed. And the source itself concludes by emphasizing the potential payoff. It suggests patents can offer great value and increased returns on the investment poured into developing new technology. It really stresses the importance of having an intelligent strategy.
A strategy for what?
For patenting. Aligning your business interests with your patent choices, thinking carefully about how, where, and when to seek patent protection, considering international routes, understanding the specific rules in different countries. The source suggests this strategic thinking can lead to savings and ultimately stronger, better rights.
So hopefully walking through this material together has helped provide you, the listener, with a much clearer understanding of the fundamental aspects of patent law here in India, drawing strictly from the information presented in this source.
And it brings up an interesting tension, doesn't it? We've talked about the strong exclusive rights of patent grants, that temporary monopoly. But the source also clearly highlights mechanisms like compulsory licenses and government use, especially for essentials like medicine, that can override those rights in the public interest. This inherent balancing act prompts a question worth considering.
Which is?
How well do patent systems, like the one described in our source, actually manage this balancing act? How do they weigh the inventor's right to exclusivity and the potential for profit against the public's very real need for access to important technologies, particularly in critical areas like healthcare? It's a constant challenge inherent in the system.
A very important point to think about.
Definitely food for thought.
Thanks for listening. Stay tuned for more coming episodes.